Okay, another example of it came from the comment section. People asking about without prejudice. What does it mean? Um, what are the consequences of something being found to be without prejudice? Okay, to put it simply, the rule is that without prejudice means that any admissions made during genuine attempts to settle a dispute shall not be admissible in any subsequent legal proceedings. So that sounds, straightforward enough. We come back to this thing that courts like people to settle cases. They don't like having trials. So they put a lot of pressure on people to settle, which we'll come to another time about, sort of the cost implications. But also they encourage people to settle by saying, look, you can have free and frank discussions about this. And it's, there's going to be no sort of downside to that. So now, when you write to people, because this happens all the time, you raise a dispute, you can try to settle things without any sort of admissions. Look, without any admission of liability, I will offer you this amount of money if you'll just go away, for instance, like that. There's no admission. But what if, for instance, it was something like, okay, will you settle for an apology and we'll put things right? I mean, arguably that's an admission. But that might be, all somebody wants. So we don't want to discourage people from doing that sort of thing. So without prejudice, it can be in writing, or it can be verbal, or it can even be by conduct. You could send somebody a flower basket and say, will you accept that? Generally speaking, when we're writing, we actually put on this is without prejudice, and we also add something called save as to cost, which I'll come to in a moment. But we explicitly say something is without prejudice. However, whether or not something is marked as without prejudice isn't actually definitive as whether it is, because, like I say, it's got to be this genuine attempt to settle a case. Okay, if it's a genuine attempt to settle a case, it might be considered to be without prejudice, even if you don't mark it as such. But if it's something beyond that, you can't protect, discreditable conduct by just marking without prejudice. So say, for instance, and this is something where there's an exception, because there's always exceptions to every rule, when things become admissible. Say, for instance, you're making it clear that this is sham litigation. I am bringing this claim and I will just do this to harass you. Or you make it clear that you'll disappear and you won't be around for any cost order. Even if I lose, I don't care. You'll never enforce the cost because I'll hide all my assets, or I'll go to live in somewhere with no extradition treaty. Then you'd be able to put those in. Another time is when you're actually arguing and saying, look, there's no claim here because we've already settled this. And the other's like, oh no, we haven't settled it. Then you can put in the material to show that. We also have without prejudice meetings. I mean, that's a very common thing with lawyers. Look, shall we just sit around a table and try and thrash this out? Because English civil litigation now is so front-loaded, very cards on the table, and lawyers can usually semi-predict what's going to happen. We think the judge is more likely to find this than this. So we will try to sort things out. But in those situations, we quite often concede other points of each other's case. I do this all the time. I will say, look, I accept you've got a good run on that, you've got a bit of a punt on that. However, if the judge believes our witness on this, or if we can show this. So we will actually discuss the case in quite some detail, the pros and cons of it, because, we're trying to reach an agreement that everybody can live with. Ultimately, it's like, well, we're never going to find out who was wrong or right, but we're just going to sort of try to get a solution where everybody can walk away equally peed off. I mean, nobody ever walks away from settlements sort of going like, wow, I'm really glad about that. Everybody loses something. But that's why, if these negotiations, if we got to court and say, well, actually, in that meeting, he admitted that, they were wrong, or the driveway was in the wrong place or something like that. Courts just go, no, we're not going to have that. And it's such a strong sort of, method of protection. To give one example, there was a boundary dispute case, okay? And when it got to trial, the issue was, we don't accept these other people have title. We don't, we have no knowledge that this is their land. We don't know what it is. It's all up for grabs, and we say the title belongs to us. The other side tried to put in a letter where previously they'd said, can we buy the land off you? Which they said, that is them accepting this is our land. And the judge said, well, no, because that was an attempt to settle, what is now this dispute as to, they wanted the land, now they're suing for it. The mere fact they tried to buy it, I'm not going to hold that against them. So that gives you an idea, because you might be thinking, well, hang on a second, that is, one of the exceptions is you can prove perjury, for instance, without prejudice. If somebody explicitly denies something, or somebody implicitly admits something in without prejudice correspondence or in a meeting, and then goes in the witness box at the trial and says, "Nope, don't know what you're talking about." That could be then a situation, with the other video about how hard it is to prove perjury, but say, look, hang on, that's clearly a blatant lie. So like I said, there are also exceptions. What are the consequences, though? Say we have a trial, and at the end of it, one side wins, and then so the other side gets some money. But then the defendant says, "Well, hang on a second. We tried to sell. We offered them more than this, or nearly as much as this, like a year ago." Then you want to put that correspondence in to show that you've tried to negotiate that sort of stuff. And that's why, to just ensure that people can't say, "Well, no, sorry, it's without prejudice, can't refer to it at all," we usually put without prejudice, save as to costs. You'll see that on emails, we just usually put WPSATC, because we all know what that means. But like I say, the mere fact that's on there doesn't necessarily mean it's without prejudice. And sometimes you will have to filter things out. It's like, well, this bit was a genuine attempt to settle, but this bit was just slagging the other side off or making threats. So, that's admissible. You can, though, deliberately send things as open correspondence. This is our offer, this is open correspondence, and if this goes to court, we'll show this to the judge. To try and show you're the reasonable one. Now, of course, theoretically, that shouldn't matter, because at the trial, the judge will just try the case on the law and the evidence. But it never hurts to look like you're the reasonable one, and that you've tried to settle this. There is this thing where courts like settlement and mediation and stuff like that, and alternative dispute resolution. So there's a lot of pressure for people to do that. There's a big pendulum as to whether that's allowed or not, because it tends to swing from, "Oh yes, we want to encourage people to settle," to, "Oh no, they're Article 6 rights, they've got an absolute right to a trial and you can't penalise them for doing that." Some contracts will actually have we need to try to settle this before issuing proceedings. Either let an arbitration clause, or just some form of alternative dispute resolution. So read the small print, because if you're in one of those contracts and then you try to sue, when you issue a claim, it goes with a form and acknowledgement of service, and it's got 3 boxes: admit the claim, deny the claim, but it's also got court doesn't have jurisdiction. And you can tick that box if you can say, well, actually no, because there's a arbitration clause or something saying we have to try to settle this before we take things to court. And the great thing about that is you don't have to file a defence. You just have to say, we don't, the court can't get involved in this until we've gone through this procedure. So I hope that's useful, because this is something that crops up a lot in everyday litigation. Because even if you're in these small claims track, where costs, each side picks their own costs up in that. Now, there can be an exception, which is if the conduct of the case was totally unreasonable, then they can say, well, actually, the losing side should pay the costs for this one, especially if it's like a losing claimant. And it's really handy then to have you without prejudice stuff to say, look, this was a sham trial, it should never have got here, so you should go for the exception to costs. But also in just big litigation, because you can say, we tried to settle this. We wouldn't be here, and our offer wasn't that unreasonable. So, okay, so we've lost today, but it should be reflected in costs that we're almost there. But I'll do another video about specifically what we call Part 36 offers and Calder banks, but I'll do that very, very shortly. But there you go. That's without prejudice. And before the duck reminds me, if you found that useful, please consider clicking the like button. And if you want more of this contact, I'm not going to edit this. I do these in one take. More of this content. For more of this content, consider subscribing. And like I say, thanks for putting things in the comments, because it's really useful to know what you want to hear about. So, see you soon.